The Justice Department has started making public the last set of materials from its Jeffrey Epstein inquiry. Deputy Attorney General Todd Blanche stated that these files would become available progressively during the day. Among them are upwards of 2,000 video recordings and over 180,000 pictures. Some sections feature such sensitive and explicit content that people must verify their age as adults to view them. Survivors of Epstein's crimes have spent years advocating openly for these records to be disclosed completely. Only after Congress approved a bill with strong support from both parties did this step forward become reality. Those harmed by Mr. Epstein suffered deep and lasting trauma, something no reasonable person would deny. Any irritation over the long wait for transparency makes sense, considering the serious details already known about his behavior. I have confidence that the skilled team at the department worked diligently these past couple of months to handle this properly. Hello again, viewers. I'm Adam, your host. Let's focus on an important story that's getting far less attention than it deserves. While people stay caught up in whatever Trump posts online or the newest headline drama, a much weightier issue is taking place quietly, literally in sealed-off rooms. At this very moment, judges and high-level government personnel are in secure locations, going through paperwork that the average person will likely never see firsthand. Fresh reporting from NPR shows the Justice Department kept back certain parts of the Epstein collection that discuss claims involving President Trump. This covers references to alleged sexual abuse of someone underage, plus additional sheets naming him that didn't make it into the open version. Democrats serving on the House Oversight Committee raised alarms about this today, indicating that intentionally holding back such details could potentially break the law. What we're really after are the fully open editions. No covered up spots, no concealed people, no deleted sections, just the straight documents that name Trump and plenty of other notable individuals. Some people who've gained entry are now sharing limited observations, and the picture they're painting raises serious concerns. Take a look at what's unfolded lately in New York. A federal district judge required the Justice Department to address what he termed significant problems in how they'd hidden private details in the Epstein paperwork. Evan Perez is with us to break it down. Evan, questions have swirled for a while about Trump's mentions in these records. Recent information points to the FBI creating a rundown of related accusations back in August. What can you share from your sources? That's correct. This list came together in 2025. The FBI gathered details on multiple claims of sexual wrongdoing aimed at the president, some reaching back many years or even decades, loosely tied to the Epstein situation. Naturally, we can't confirm how solid any of these are. Officials think quite a few lack supporting evidence. A lot come from indirect sources, stories retold second or third hand. The whole purpose of these Epstein documents was to shed light on links to one of the most reviled criminals of our era. Instead, the handling of privacy protections went so wrong that some survivor names and pictures ended up exposed unintentionally to the public. It's astonishing. Their main responsibility was to shield victims and present facts clearly. They didn't succeed in either area. Judge Richard Berman made his dissatisfaction plain. He criticized the authorities sharply, demanded swift fixes, and later dropped a planned court session after the required changes happened, thanks to court involvement. The BBC noted that thousands of Epstein-linked items were pulled offline temporarily once survivors pointed out that the privacy edits hadn't done enough to keep them safe. This isn't some tiny slip-up. It highlights a larger failure in managing one of the biggest public releases of sensitive government material we've seen recently. Particularly noteworthy was a CNN segment on February 9th, featuring Representatives Thomas Massie and Ro Khanna. After looking over the complete, untouched Epstein records in a restricted space, they expressed belief that excessive blackouts are hiding the roles of at least 6 high-profile men. Let that register. No fewer than 6 people with real clout have their names and associations kept from everyday view. These members of Congress saw the raw files, nothing blocked, and they're cautioning that what's out there publicly is nowhere near the whole truth. For some context, Massie is a Republican representing Kentucky. Khanna is a Democrat from California. They seldom find common ground, but after reviewing identical materials, they drew the same conclusion. Influential figures are getting shielded, leaving the rest of us uninformed. This isn't about one side or the other. It's a cross-party recognition that key information is being withheld. Focusing on Trump now, his name comes up often in these files. The Justice Department put out roughly 3.5 million pages tied to the Epstein probe. 3.5 million, no exaggeration. Buried in their official notice, they added a direct warning. Specific sections include baseless and dramatic accusations about President Trump handed to the FBI just ahead of the 2020 vote. To clarify, the government holds millions upon millions of pages, including grave accusations aimed at him. They call some unreliable, but won't pinpoint which ones. They simply release the lot with a short caveat and frame it as full disclosure. This method invites doubt. Judges see the entire set. Investigators review it all. Certain lawmakers get secure access to everything, but the public gets a version stripped of details, plus a loose note saying bits might be invented. We're asked to trust that the select few with complete visibility are making fair choices about what everyone else learns. Still, the courts do have that full access, and that fact holds real importance legally. Even if uncensored details stay private, they can fuel criminal probes, civil actions, or other reviews without ever going public. So when someone wonders if Trump faces actual jeopardy from these files, the fair answer is that it's not impossible. We don't have details on what judges are privately reviewing. We can't say what threads investigators might pull from those millions of pages, but it's evident that a number of prominent people are feeling uneasy right now. The judge's recent directive to correct departmental mistakes, alongside lawmakers openly noting protections for powerful individuals, shows this issue isn't fading anytime soon. To grasp what uncensored files truly mean, people often picture minor tweaks to official papers with fewer black marks. The reality is far more dramatic. One version leaves out huge chunks, while the other delivers the full sequence. Exact people, dates, actions, and who else took part. In legal proceedings, having that full view can tip the balance between acquittal and conviction. Government bodies routinely blank out sections when sharing records, names, precise times, locations, claiming reasons like privacy needs, security concerns, or protecting live cases. Often those choices hold up. Keeping a survivor's name private is fair. Protecting secret sources is valid, but occasionally, these edits seem aimed more at sparing well-placed people from discomfort or legal trouble. Since the hidden parts stay hidden, the public can't tell justified caution from improper cover. Yet judges, federal prosecutors, and lawmakers with clearance can pierce that veil. That's the divide playing out today. Regular folks see a sanitized story. Those central to justice see the unedited facts. More and more, certain people on the inside are pointing out how wide that divide really is. Massey and Khanna avoided naming anyone. They're restricted by rules. But they stressed plainly that the public release misses crucial pieces. A Republican and Democrat agreeing on this point makes it clear. This isn't partisan. It's about government secrecy versus the public's entitlement to the complete picture. On the New York mishandling, Judge Berman announced openly that the federal side had pledged to repair major redaction problems. Those problems were bad enough to let victim names and visuals slip through unprotected. The agency charged with guarding survivors and handling delicate files made such obvious blunders that a federal judge had to step in and order fixes. This wasn't handled quietly. The judge put out a public note, called off an upcoming hearing, and said he was glad, though hardly shocked, that things got sorted only after court pressure applied. Put simply, the court had to force basic competence. When protections for victims failed this spectacularly, it prompts questions about other lapses. What else might be overhidden to help people who shouldn't get that benefit? That's the exact issue Massey and Khanna highlighted, and plenty of others share their worry. These Epstein files go much further than one person. They expose a broad web of rich, influential connections to his circle. Some were harmed, some spoke as witnesses, others might share blame. The main takeaway, this network involves individuals so powerful that the Justice Department treads extremely carefully on what gets out. As a result, the public gets a polished, limited version. Meanwhile, those with real sway, judges, prosecutors, approved lawmakers, see the raw truth. A handful are now hinting that the actual details are much darker than what's been officially shared. Massey and Khanna didn't need to go on CNN and state that redactions seem to protect at least 6 prominent men. They could have stayed quiet after their review, but they spoke out. That decision carries weight. It indicates what they encountered was troubling enough to warrant public mention, even without full details. It suggests the redaction process goes beyond safeguarding victims to cover possible wrongdoers. It shows some inside government are fed up with ongoing protection for those who should answer for their actions. The redaction process is meant to manage sensitive data carefully. Sometimes that's essential. But when the government admits to major errors that put survivors at risk, and when bipartisan lawmakers claim overzealous hiding benefits the elite, the process isn't functioning, it's failing. The fact that a judge had to compel corrections proves the department wasn't going to self-correct. They seemed okay releasing flawed batches until forced otherwise. Every withheld detail, every excessive blackout, every huge dump paired with warnings about false sensational claims feeds the very suspicion officials say they're trying to dispel. Without straightforward access to all facts, people naturally fill gaps with theories. In a case centered on Epstein elite ties and charges against a former president, those theories explode. True openness from authorities could cut down on much of that, but complete candor would force real consequences, and consequences threaten those at the top. That clashes with how things usually operate. Where does Trump stand in all this? We can't say for sure yet. What's certain? Judges have reviewed untouched records that mention him. The department admits accusations against him exist in the files, though it downplays some as unfounded. Lawmakers have indicated shielding for key figures. The legal system keeps evaluating material most of the public won't fully access. That setup creates real exposure. Even without charges right now or proof of every allegation, the presence of this material and its examination by those who can act means legitimate risk exists. There's a slim but non-zero chance some pieces could lead to action later. This is the central alert. Not guaranteed prison tomorrow, not new charges today, but steady progress in the justice machinery. Courts are looking closely, probes are advancing. The space between what officials know and what we know is where serious danger can hide. In big cases like this, decisions often turn on what's hidden from view. Unredacted evidence, closed-door proceedings, private discussions. Public insistence is what pushes change forward. Judge Berman didn't demand fixes out of nowhere. He acted because survivors raised alarms, errors were too blatant to ignore, and broad frustration left no room for inaction. Massey and Khanna didn't speak on air for political gain. They did it recognizing the call for answers, the rising anger, and knowing quiet acceptance would keep things stuck. Real shifts come less from the system running smoothly on its own, and more from outside pressure making it work. That pressure is mounting now. Every story on redaction failures, every comment from officials about hidden facts, every hint of special treatment for the powerful ads fuel, eventually it has to lead somewhere. The Epstein files aren't disappearing. Calls from survivors, lawmakers, and everyday people won't stop. While a clear gap remains between court access and public view, valid questions about selective hiding will linger. Trump appears in these records. Claims against him are there too. True or not, their existence and review by people with authority to pursue them keep this story alive and developing. Remain alert. When you catch updates on more redaction problems, pushes for clarity, or court orders for extra releases, keep in mind the foundation, genuine files with real names and weighty accusations. Some names tie to the world's most influential people, some accusations, if validated, could alter perspectives in major ways.